Case 1, Patricia Ripley, May 21, 2020, Miami-Dade County. There are moments in the work of law enforcement that cannot be prepared for. Moments that arrive without warning and leave a permanent mark on every officer, every investigator, and every first responder who encounters them. The evening of May 21, 2020 was one of those moments for the men and women of the Miami-Dade Police Department. What began as a frantic call from a distressed mother, a story that sounded like every parent's worst nightmare, would unravel over the course of a single night into something that shook the entire South Florida community to its foundation. This is not a story that is easy to tell, but it is a story that must be told, because at the center of it was a 9-year-old boy named Alejandro Ripley, a child who deserved protection, who deserved safety, and who deserved every chance at a life full of the love and care that every child is owed from the moment they enter this world. Alejandro Ripley was 9 years old in the spring of 2020. He was nonverbal, having been diagnosed with autism at an early age, and his entire world depended on the adults around him. He could not call for help. He could not describe what was happening to him. He could not run to a neighbor or flag down a passing car. Alejandro was, by the very nature of his condition, entirely dependent on his mother, Patricia Ripley, for everything, for food, for shelter, for comfort, for safety. That dependency, which should have been the foundation of an unbreakable bond, would instead become the circumstance that made him most vulnerable on the night his life came to an end. Patricia Ripley was 42 years old at the time. She lived with Alejandro in the Kendall area of Miami-Dade County, a sprawling suburban community in the southwestern part of the county, known for its residential neighborhoods, its strip malls, and its network of canals, the kind of engineered waterways that crisscross much of South Florida, remnants of the drainage systems built to make the low-lying land habitable. Those canals, quiet and largely unremarkable features of the Kendall landscape, would become the defining location of what happened on the night of May 21st. At approximately 7:30 in the evening, residents near a canal in the Kendall area heard a commotion. A child was in the water. A bystander, whose quick instincts and courageous action that evening represent one of the few moments of grace in an otherwise unbearable story, entered the water and pulled Alejandro to safety. The child was alive. He was frightened and disoriented, but he was alive. Emergency services were contacted, and Patricia Ripley, who was present in the vicinity, immediately launched into a story that she had clearly prepared in advance. She told officers that 2 men had approached her and her son. She described the encounter with urgency and apparent distress. She said the men had grabbed Alejandro and thrown him into the canal. She gave descriptions. She expressed terror. She played the role of a horrified mother with a conviction that, in those initial moments, drew sympathy from everyone around her. Investigators began the process of treating the incident as a possible kidnapping attempt. Resources were mobilized. The account was taken seriously. But something was already pulling at the threads of her story. Investigators are trained to listen not just to what people say, but to how they say it, and to what the surrounding evidence confirms or contradicts. And the surrounding evidence, captured on surveillance cameras positioned throughout the Kendall area, was telling a very different story from the one Patricia Ripley was presenting. The footage did not show 2 men. It did not show a struggle, a chase, or a random attack. What the surveillance footage showed was Patricia Ripley herself, alone with her son, at the edge of the canal. What it showed was a mother, not a pair of strangers, placing her child in the water. That footage was a turning point. But before investigators could fully process what they were seeing, before the weight of that evidence could be acted upon, Patricia Ripley had already moved. Approximately 1 hour after the first canal incident, 1 hour after Alejandro had been pulled from the water alive by a stranger willing to risk their own safety for a child they did not know, Patricia Ripley took her son to a second location. The second location was near the Kendall Lakes Golf Course, another stretch of the same kind of quiet, unremarkable South Florida canal that defines so much of the area's geography. It was here, at this second site, that Alejandro Ripley lost his life. He did not survive this encounter with the water. The child who had been rescued once that evening, who had been given a second chance at life by the intervention of a stranger, was not rescued again. When investigators pieced together the timeline of that night, the first canal, the fabricated story about 2 men, the rescue, the 1 hour window, and then the second canal, The picture that emerged was one of deliberate, premeditated action. This was not a momentary lapse. This was not a single terrible decision made in a moment of crisis. The deliberate nature of the sequence of events, the false report designed to create an alternative explanation, the return to the water after the first attempt had been interrupted, pointed to a level of planning that investigators found deeply significant. Patricia Ripley was taken into custody. She was charged by the Miami-Dade State Attorney's Office with first-degree murder in connection with Alejandro's death, as well as attempted murder in connection with the earlier canal incident. The charges reflected the severity of what the evidence showed. The State Attorney's Office announced that they would be seeking the death penalty. Patricia Ripley, if convicted of first-degree murder, would face the possibility of the ultimate punishment under Florida law. The case moved through the Miami-Dade court system over the months and years that followed. The filing of capital charges meant that the legal process was necessarily careful and methodical. Defense attorneys and prosecutors engaged in the pretrial proceedings that are standard in death penalty cases. Motions were filed, evidence was reviewed, and the question of Ripley's competency to stand trial was examined. A trial date was tentatively set for August 26, 2024. Throughout the legal proceedings, the broader South Florida community grappled with the facts of the case in a way that went beyond the courtroom. Alejandro's story resonated with parents, with advocates for children with disabilities, and with the many families across Miami-Dade who live in communities where similar canals run quietly behind backyards and alongside roadways. Organizations that work with families of children with autism and other developmental disabilities spoke publicly about the resources, respite care, crisis intervention, mental health support, and family assistance programs that exist for parents who are struggling, and about the importance of reaching out before a moment of desperation becomes irreversible. That conversation, the one about what resources exist, about how communities can support families under pressure, about how systems of care can be strengthened, is one of the most important conversations that a case like this one can generate. Because while the legal system must hold individuals accountable for their actions, a community that is serious about protecting its most vulnerable members also has to ask the harder question. What can be done, upstream of tragedy, to ensure that children like Alejandro never find themselves in a moment of danger in the first place? The National Center for Missing and Exploited Children and the Autism Society of America both maintain resources for families of children with autism who are navigating crisis. The Florida Department of Children and Families operates a child abuse hotline at 1-800-962-2873 for anyone concerned about the welfare of a child. These resources exist because communities have decided that children deserve protection not just from the courts after the fact, but from the systems and support networks that can intervene before the worst happens. Alejandro Ripley was 9 years old. He was nonverbal. He trusted the person who was responsible for his safety. That trust was betrayed in the most irreversible way possible. The legal process in Miami-Dade County continues to work toward a conclusion that holds Patricia Ripley accountable for what the evidence shows occurred on the night of May 21, 2020. And in courtrooms, in community centers, and in the quiet conversations of families across South Florida, Alejandro's name continues to represent something that this community refuses to forget: the absolute and unconditional obligation that every child is owed: safety, dignity, and the chance to live. The Florida court system, the advocates who have spoken in Alejandro's name, and the bystander who entered the water that evening to save a child he did not know, all of them are part of the record of this case. The legal proceedings will ultimately deliver a verdict. But the community's verdict, in terms of how it chooses to protect its most vulnerable children going forward, is one that does not wait for a courtroom. Justice for Alejandro Ripley means accountability under the law. It also means a community that learns from what happened on the night of May 21, 2020, and commits itself to ensuring that the children who cannot speak for themselves are never left without someone to speak for them. If you believe this story deserves to be heard, please take a moment right now to like this video and subscribe to Cold Case Hour. Your support helps this channel continue bringing these important stories to light. Every like, every comment, and every subscription is a vote for accountability, for justice, and for the victims whose stories deserve to be told. Case 2, Odette Joassaint, April 12, 2022, Miami-Dade County. In the Little Haiti neighborhood of Miami, community runs deep. It is a neighborhood built over generations by families who brought with them from the island of Haiti a culture of resilience, of faith, of fierce devotion to family and to the bonds that hold a community together. Little Haiti's streets carry the sounds of Haitian Creole, the colors of its art, the rhythms of its music, and the warmth of a community that has survived extraordinary hardship to build something enduring in the heart of South Florida. It is a neighborhood where neighbors know each other, where the presence of children in the streets and courtyards of apartment complexes is a familiar and welcome feature of daily life. And it is a neighborhood where the events of April 12, 2022 arrived with a force that the community is still processing. On that April morning, residents of an apartment complex in Little Haiti noticed that something was wrong. The sounds coming from one unit were unusual, not the ordinary sounds of a family going about the morning routine, but something more distressing, more disorganized, more alarming. A woman's voice. Repeated calls to emergency services. The kind of repeated, fragmented contact with 911 that signals not a single emergency, but a state of ongoing crisis. A mind reaching out for help in a way that is not quite coherent and not quite explainable by any single, definable event. The woman placing those calls was Odette Joassaint. She was a resident of the apartment complex, a mother of 2 young children, a 3-year-old son and a 5-year-old daughter. The calls she placed to emergency services that morning were multiple. The content of those calls was fragmented and difficult to interpret. By the time officers from the Miami-Dade Police Department arrived at the apartment, what they found inside was a scene that would stay with them for the rest of their careers. Odette Joassaint was present in the apartment. Her demeanor was described by responding officers as delusional, not threatening in a confrontational sense, but disconnected from reality in a way that was immediately apparent to every person who entered that space. She was not behaving like a person who was aware of what was happening around her in any conventional sense. She was in a state that experienced officers and mental health professionals would describe as a psychotic episode, a break from shared reality, so complete that the person experiencing it is, in a meaningful sense, living in an entirely different version of events than the one visible to everyone else. Inside the apartment's bedroom, investigators found Odette Joassaint's children. Her 3-year-old son and her 5-year-old daughter had been restrained, their hands, feet, and necks bound in a manner that investigators documented carefully as part of the evidence collected at the scene. Both children had lost their lives. The medical examiner's findings indicated that the manner of their deaths was consistent with strangulation. The 2 youngest members of the Joassaint family, children who had barely begun to experience the world, did not survive the night of April 11th into the morning of April 12th, 2022. The investigation that followed moved on 2 parallel tracks that are both essential to understanding this case in full. The first track was the criminal investigation, the collection of evidence, the documentation of the scene, the autopsy findings, the charging decisions made by the Miami-Dade State Attorney's Office. On that track, Odette Joassaint was charged with 2 counts of first-degree murder. She was taken into custody and held without bond. The charges reflected the severity of what investigators had documented. The criminal justice process in Miami-Dade County was now responsible for determining how the law would respond to what had occurred in that Little Haiti apartment. The second track, the one that ran alongside the criminal proceedings and in some ways raised even more complex questions, was the mental health track. The behavior described by responding officers, the multiple fragmented calls to emergency services, the delusional state that was immediately apparent upon their arrival, the nature of the actions that had been taken, all of it pointed toward a person who was not operating within any normal frame of awareness or intent on the morning of April 12th. The question of Odette Joassaint's mental state at the time of the offense, her capacity to form criminal intent, her awareness of the nature and consequences of her actions, the degree to which a recognized psychiatric condition may have been driving her behavior, became a central and contested element of the legal proceedings. Mental health crisis in the context of a violent criminal case is one of the most difficult and sensitive areas of both law and public understanding. The legal system is tasked with adjudicating individual responsibility. The mental health system is tasked with providing care and treatment. And the community is left trying to understand how both of those systems can and should respond when a person who appears to have been in acute psychiatric crisis causes irreversible harm. The Little Haiti community's response to the Joassaint case was layered and complicated in ways that reflect the complexity of the case itself. There was grief, profound, community-wide grief, for the children who had lost their lives. There was also, among those who knew the family or had observed Odette Joassaint in the weeks and months before April 12th, a set of questions about what had been noticed, what had been reported, and what resources had or had not been accessible or utilized. Were there signs that she was struggling? Were there people in her life who had noticed something alarming? Were there avenues through which intervention might have been possible before the morning of April 12th? These questions do not assign blame to anyone other than the individual who made the choices that led to those children's deaths. But they are the questions that a community committed to preventing future tragedies must be willing to ask honestly and without defensiveness. Mental health crises do not always announce themselves clearly. They do not always present in ways that make intervention simple or obvious. But the more a community understands about what acute psychiatric crisis looks like, the more it talks openly about mental health, the more it reduces the stigma that prevents people from seeking help and from flagging concern about others, the better the chance that the next crisis is reached and addressed before it becomes irreversible. The Florida Department of Children and Families operates crisis mental health services throughout Miami-Dade County. The Miami-Dade Crisis Center provides 24-hour support at 305-379-2999 for individuals and families navigating mental health emergencies. These are resources that exist because the community has recognized that mental health crises are health events that require care, intervention, and support, not just criminal response after the fact. The 3-year-old and the 5-year-old who lost their lives in that Little Haiti apartment on April 12, 2022, deserve to grow up. They deserve to know the neighborhood their family had built a life in. They deserve the future that every child in Miami-Dade County is owed. The criminal justice system in Miami-Dade County is working to ensure that Odette Joassaint is held accountable for what happened to her children. And the broader community carries with it the responsibility to honor those children's memory by doing everything possible to ensure that the next family in crisis has a place to turn before the worst happens. The legal proceedings in the Joassaint case remain active in the Miami-Dade court system. The charges are serious. The evidence is documented. And the outcome of those proceedings will be a matter of public record. One more entry in the long account of cases through which the justice system of Miami-Dade County works to protect its most vulnerable residents, even when that protection must come, as it too often does, after the fact. 2 children, a 3-year-old boy and a 5-year-old girl. They deserved every day they did not get to have. Their story is part of the record now. And the community of Little Haiti and the broader community of Miami-Dade carries that record forward with a commitment to doing better for every child, in every household, on every block of this city. If this story moved you, if you believe these children's names deserve to be remembered, please like this video and subscribe to Cold Case Hour. Leave a comment below. Your engagement keeps this channel alive and keeps these stories reaching the people who need to hear them. Case 3, Precious Bland, August 23, 2021, Miami-Dade County. The summer of 2021 was still marked, in homes across Miami-Dade County and across the country, by the long shadow of the COVID-19 pandemic. The disease itself had receded somewhat from its worst peaks, but the psychological toll it had taken on families, the isolation, the fear, the economic stress, the grief, and in some cases the profound disruption to mental health, continued to ripple through communities in ways that were not always visible from the outside. In many households, the past 18 months had been a period of sustained pressure unlike anything most families had experienced in their lifetimes. And in some homes, beneath the surface of daily routines maintained against all odds, something was fracturing in ways that the people inside those homes did not have the tools or the support to stop. Precious Bland was a resident of Miami-Dade County, a wife and a mother living in a household that included her husband, her 16-year-old daughter, and her 15-month-old daughter. In the weeks and months leading up to August 23, 2021, those who knew her had observed changes in her behavior and thinking that, in retrospect, were consistent with an accelerating mental health crisis. The pandemic had amplified fears that in a different context might have been manageable, fears about contamination, about invisible threats, about the safety of those she loved. In Precious Bland's case, those fears had taken on a specifically religious dimension that distorted her perception of reality in ways that were not immediately apparent to everyone around her. By the morning of August 23, 2021, something had shifted in Precious Bland's perception of the world in a way that was acute and beyond her control. Her husband was present in the home. Her 16-year-old daughter was present. And her 15-month-old daughter, a toddler just past the age when children begin to walk and explore their world with the wide-eyed curiosity that is one of the most beautiful things a parent ever witnesses, was present. What happened inside that household on the morning of August 23 began with Precious Bland in a state of acute psychiatric crisis. According to the investigation and the accounts provided to authorities, she had become convinced that a moment of profound spiritual significance was arriving, that a purification was necessary, that a sacred act of cleansing was required of her. The bathtub in the family home became the center of that delusion. She spoke aloud about what she believed she was called to do. She declared, in words that her family heard and that were documented in the investigation, that a spiritual reckoning was at hand. Her 15-month-old daughter was placed in the bathtub. The child did not survive. She was 15 months old. She had been walking, perhaps for only a few weeks, perhaps for a couple of months. She had the particular, lurching, triumphant walk of a toddler in the first flush of mobility, that walk that makes parents laugh and hold out their hands and marvel at the creature they have brought into the world. She did not survive August 23, 2021, when Precious Bland's husband and her 16-year-old daughter attempted to intervene, when they tried to stop what was happening, tried to reach her, tried to pull her back from the edge of whatever reality she was inhabiting in those moments. She responded with violence toward them as well. Both her husband and her older daughter sustained injuries during the confrontation. Both survived. Both were left to carry with them the trauma of what they had witnessed and experienced inside their own home on what had begun as an ordinary summer morning. Precious Bland was taken into custody by Miami-Dade police. She was charged with second-degree murder in connection with her 15-month-old daughter's death, and with attempted murder and child abuse in connection with the harm caused to her husband and surviving daughter. The charges filed by the Miami-Dade State Attorney's Office reflected the nature of what investigators had documented. The mental health dimension of this case was, from the beginning, inseparable from its legal dimension. The investigators, the prosecutors, the defense attorneys, and the court all had to grapple with the question of how the law accounts for a person whose actions, however devastating, however irreversible, appear to have been driven by a break from reality so profound that the normal categories of criminal intent become genuinely difficult to apply. Florida law provides for an insanity defense in cases where a defendant, at the time of the offense, did not know what they were doing or did not know that what they were doing was wrong. The application of that defense in any specific case requires detailed psychiatric evaluation and is ultimately a question for a jury to decide. What is not in dispute, what is documented, charged, and before the courts, is the outcome. A 15-month-old child lost her life. A husband and a 16-year-old daughter were harmed inside a home that should have been their place of safety. And a family that was already, by all indications, under profound stress found itself at the center of a tragedy that no resource, once it reached the morning of August 23, could undo. But resources could have made a difference before that morning. The conversation about pandemic-era mental health, about the particular vulnerability that prolonged isolation and fear created for individuals who were already managing fragile mental health conditions, and about the support systems that were or were not in place to catch people before they reached a point of acute crisis, is one that the Bland case puts directly on the table. Mental health professionals who studied the pandemic's impact on communities across the country noted a significant increase in untreated psychiatric crisis during the periods of maximum social isolation. Systems that had been underfunded for years were overwhelmed. Families were navigating crisis without access to the professional support they needed. The Florida Crisis Hotline is available 24 hours a day, 7 days a week, at 1-800-273-8255. For families navigating mental health concerns related to a family member, the National Alliance on Mental Illness operates a helpline at 1-800-950-6264. These resources exist because the community has decided that crisis intervention before harm occurs is both possible and essential. Precious Bland's 15-month-old daughter had a name. She had a face. She had a walk. That new, unsteady, triumphant toddler's walk that her family will carry in their memory for the rest of their lives. The legal proceedings in Miami-Dade County are working toward accountability. The community is working, imperfectly and incrementally, but genuinely, toward the kind of mental health infrastructure that this case reveals as urgently necessary. Justice in this case means accountability under the law. It also means a sustained, serious, and well-funded commitment to mental health support for every family in Miami-Dade County that is struggling, before the morning comes when struggling becomes something that cannot be walked back from. If you want to see more stories like this one, stories told with the gravity and respect they deserve, please like this video, leave a comment, and subscribe to Cold Case Hour. It takes only a moment, and it means everything to this channel's ability to keep doing this work. Case 4, Tinessa Hogan, June 21st through 22nd, 2021, Broward County. South Florida's canal system is one of the most extensive in the country. The canals that run through Broward County, through its residential neighborhoods, behind its apartment complexes, alongside its golf courses and parks, were engineered to manage water in a landscape that sits at or below sea level, a flat, subtropical terrain where water has always been both a resource and a risk. For the most part, those canals are simply features of the environment, present and unremarkable in the daily life of millions of residents. But periodically, and always with a weight that the entire region feels, they become the location of the most devastating kinds of loss. The summer of 2021 in Broward County had already been marked by the kind of news that sits in a community's chest without resolution. The Champlain Towers collapse in Surfside, just to the south in Miami-Dade, had shaken the entire region in late June of that year. The atmosphere was one of heightened grief, of collective shock, of a community processing loss on multiple fronts simultaneously. It was into this atmosphere that the events of June 21st and 22nd, 2021 arrived, events that unfolded not in a sudden disaster, but across a night and into a morning in the quiet residential streets of Lauderhill. Tinessa Hogan was a resident of the Lauderhill area of Broward County, a mother of 2 daughters. Her older daughter was 9 years old. Her younger daughter was 7. They were school-age children, children with friends, with teachers, with routines, with all the small particular enthusiasms and habits that belong to children at those ages. They were known to people in their community, to their neighbors, to the families around them. On the evening of June 21st, 2021, residents of the neighborhood near the canal that runs through their community began noticing something alarming. A woman was in the water, not in distress, not struggling, but present in the canal deliberately, with an apparent sense of purpose. She was carrying a Bible. She was holding a sign. The sign, documented by witnesses and later by investigators, bore the words, "Death is the only way." She was, according to the accounts of multiple witnesses, offering something she described as baptisms to those she encountered near the water. The image that emerges from witness accounts is one of a person in the grip of a profound and acute mental health crisis. A person whose behavior had crossed from the unconventional into something that was, to everyone who observed it, clearly and urgently alarming. The canal, the Bible, the sign, the offers of baptism. These were the visible signals of a mind in crisis, and they were observed by people who were disturbed by what they saw. But the full significance of what was unfolding on the evening of June 21st would not become apparent until the following morning. On June 22nd, 2021, the bodies of Tinessa Hogan's 2 daughters were discovered in the canal. They were found hours apart, a detail that investigators noted and documented carefully. The 9-year-old and the 7-year-old had both lost their lives in the water. The discovery of the first child, and then, hours later, the discovery of the second, extended the horror of that morning across time in a way that was particularly harrowing for the responding officers, for the investigators, and for the community around them. Tinessa Hogan was taken into custody. She was charged by the Broward County State Attorney's Office with 2 counts of first-degree murder in connection with the deaths of her 2 daughters. She entered a plea of not guilty in July of 2021. The case proceeded through the Broward County court system with the weight of all capital cases, carefully, methodically, and with the full machinery of a justice system tasked with determining how the law responds to acts of this magnitude. The mental health dimension of the Hogan case was central and unavoidable from the moment of her arrest. Everything that witnesses had observed on the evening of June 21st, the canal, the Bible, the sign, the apparent offers of baptism, was consistent with a person experiencing a severe psychiatric break. The religious content of the delusion, the symbolic language of the sign, the behavior in the water, all of it pointed toward an acute crisis that had been visible to the community around her and that had not been intercepted before it reached its devastating conclusion. Among the questions that the Hogan case raised most directly was the question of what happened in the hours between the time witnesses first observed her behavior in the canal on the evening of June 21st and the time her daughters were discovered the following morning. Were calls made to emergency services? Were those calls responded to in a way that addressed the severity of what was visible? Were there people in Tinessa Hogan's life who were aware that she was struggling, who had tried to get help, who had encountered barriers in the mental health care system that prevented intervention? These questions are part of the broader investigation that any serious community must conduct in the aftermath of a case like this one, not to distribute blame, but to identify the points in the system where intervention was possible and did not occur, and to strengthen those points against future failure. The Broward County court system has continued to process the Hogan case through its pretrial and trial proceedings. The charges are among the most serious in Florida law. The evidence gathered by investigators is part of the documented record of the case. And the two little girls, the 9-year-old and the 7-year-old whose lives ended in a South Florida canal on the night of June 21st into the morning of June 22nd, are names that Broward County carries with it in the ongoing work of making the community safer, more responsive, and more capable of catching the next person in crisis before the canal becomes the final chapter of their story. Mental health crisis intervention resources in Broward County include the Crisis Intervention Unit operated by Broward County's Behavioral Health Division, available at 954-747-1575. Florida's statewide crisis line is available at 1-800-273-8255. These resources exist because communities across South Florida have decided that the space between visible crisis and irreversible outcome is a space that should be filled with intervention, not absence. Two little girls, 9 years old and 7 years old. They loved their mother. They trusted her. And on the night of June 21st, 2021, on the banks of a Lauderhill Canal, the system that should have protected them, and that system includes not just formal institutions but the community and the safety net of care around every family, was not where it needed to be. The justice system is working. The community must work alongside it. And those two little girls' names are part of the reason why. Please take a moment to like this video and subscribe to Cold Case Hour. Every subscription helps this channel bring these stories to the audience they deserve. Leave a comment. Your voice matters here. Case 5, Ailenys Carmenate, February 22nd, 2020, Miami-Dade County. The city of Ailenys sits in the heart of Miami-Dade County, a dense, vibrant, predominantly Cuban-American community that is one of the most populous cities in Florida. It is a city of working families, of small businesses, of households where multiple generations share space, and where the rhythms of daily life are closely interwoven with those of neighbors, extended family, and the broader community. Ailenys streets are full of children, playing, going to school, running between apartments, and living the ordinary, irreplaceable lives of childhood in the warmth of a South Florida neighborhood. On the morning of February 22nd, 2020, emergency services received a call from a residential address in Ailenys. What officers found when they arrived was a scene that required immediate response on multiple fronts simultaneously. Inside the residence were 3 children, a 6-month-old infant, a 9-year-old, and a 12-year-old. The children's mother was Ailenys Carmenate. And what the officers encountered when they arrived was the aftermath of a sustained threat to all 3 children's lives. A threat that had come not from outside the home, but from the one person in that home who was supposed to be their protection. Ailenys Carmenate had, according to the investigation conducted by the Hialeah Police Department and Miami-Dade County investigators, attempted to harm all 3 of her children that morning. The 6-month-old infant, a child who was not yet old enough to sit up unassisted, who was entirely dependent on the adults in the household for every aspect of survival, had been subjected to an attempt to restrict their breathing. The infant was alive when officers arrived. They were alive because of what happened next. The 9-year-old and the 12-year-old. Carmenate's older children, children who were old enough to understand in some fundamental way that something was terribly wrong. Children who were old enough to feel fear and to act on it, resisted. The details of that resistance, documented in the investigation and the subsequent charging documents, represent one of the most remarkable and heartbreaking features of this case. Children, a 9-year-old and a 12-year-old, fighting back against a threat that should never have existed, doing what they could with the limited power available to them to protect themselves and their infant sibling. Carmenate's boyfriend was also present or nearby during the incident. He intervened. His intervention, combined with the resistance of the older children, meant that the 6-month-old survived. The infant who had been placed in harm's way on the morning of February 22, 2020 was alive when emergency services arrived. That survival, fragile, narrow, and dependent on the courage of 2 children and the action of 1 adult, is the thing that separates this case from the deepest category of tragedy. Ailenys Carmenate was taken into custody by law enforcement and charged with attempted murder, child abuse, and kidnapping. The charges reflected the scope of what investigators had documented, that the threat had extended to all 3 children, that it had involved multiple distinct acts, and that the intent, as determined by investigators and prosecutors, was of a nature that required serious felony charges across multiple categories. The investigation examined the circumstances of Carmenate's state of mind and her situation in the period leading up to February 22. As with many cases of this kind, the picture that emerged was not one of a person who had shown no prior signs of distress. The pressures of single parenthood, economic stress, and the particular burdens of caring for 3 children, including a very young infant, are well documented as factors that can, in the absence of adequate support, push individuals toward crisis. Whether any of those factors were present in Carmenate's case, and what if any support had been available or sought, became part of the broader context that investigators and eventually the court system would examine. The 3 children, the infant, the 9-year-old, and the 12-year-old, were placed into protective care following the incident. Their immediate safety was secured. The longer-term question of their well-being, physical, psychological, and emotional, became the responsibility of the child welfare system and, ultimately, of the extended family and support network that would need to surround them in the months and years that followed. Children who experience harm at the hands of a parent carry that experience in ways that are not always immediately visible. The work of supporting them, of providing them with the care and therapeutic support they need to process what happened and to build toward the futures they deserve, is work that extends far beyond the date of arrest or the date of conviction. The Miami-Dade case against Ailenys Carmenate proceeded through the court system in the years following her arrest. The charges, attempted murder, child abuse, and kidnapping, carried significant potential penalties under Florida law. The case was one of several that moved through the Miami-Dade court system during 2020 and 2021 that raised urgent questions about the resources available to families under stress and the systems in place to identify and respond to crisis before it reaches a point of irreversible harm. The 9-year-old and the 12-year-old who fought back on the morning of February 22, 2020, did something that deserves to be acknowledged directly. They acted with a courage that adults twice their age might not have summoned. They did not have the power to fully control the situation they were in, but they did everything they could. And their 6-month-old sibling survived, in part, because of what they did. That survival is not a small thing. It is everything. It is the difference between a story about loss and a story about a child who gets to grow up. The child advocacy organizations that work in Miami-Dade County, including the Children's Trust of Miami-Dade, the Child Protection Team, and the network of family support services operated through the Florida Department of Children and Families, exist to provide the kind of early intervention and family support that can reach families before a morning like February 22 arrives. These systems are imperfect and underfunded, but they exist, and every family that accesses them is a family where the worst does not happen. 3 children, a 6-month-old, a 9-year-old, and a 12-year-old. All 3 are alive. That is the sentence that matters most in this story. All 3 survived. And the legal system of Miami-Dade County is responsible for ensuring that the person who put their lives at risk on February 22, 2020 is held fully accountable for what the evidence shows. Accountability protects children. Justice protects communities. And the courage of those two older children on that February morning is the detail that belongs in the record alongside every charge filed and every verdict delivered. Please like this video and subscribe to Cold Case Hour if this story matters to you. Sharing this content helps ensure that these cases reach the widest possible audience. Leave a comment below. We read every one. Case 6, Rachel Fryer, February 6, 2014, Putnam County/Miami-Dade County. Among the cases documented in the annals of Florida's child welfare and criminal justice system over the past decade, the case of Rachel Fryer and her 2-year-old daughter Tarihi Gordon stands as one of the most searingly painful. It is a case that exposes, with a clarity that is difficult to look at directly, the ways in which the systems designed to protect children can fail, the child welfare visits that do not catch what is happening behind closed doors, the neighbors who sense that something is wrong but cannot be certain, the legal mechanisms that move after the fact when what was needed was intervention before. Tarihi Gordon was 2 years old in the winter of 2014. She was a toddler, the age of maximum curiosity, maximum energy, maximum need for the patient and devoted care that children at that stage require. 2-year-olds are loud and demanding and exhausting and also, in ways that parents will tell you about for the rest of their lives, absolutely transcendent. The small person emerging from the infant, the personality crystallizing, the laughter and the stubbornness and the wonder accumulating into something that begins to look like the individual they will spend the rest of their lives becoming. Tarihi Gordon did not get to become that individual. On February 6, 2014, she lost her life. The medical examiner's findings documented the nature of the harm she had sustained. Injuries to her head consistent with severe physical force, evidence that pointed to a history of abuse that had not begun on February 6 but had been ongoing. Tarihi had not been safe in her home. She had been subjected to harm that was not a single incident but a pattern that had been building toward the outcome that February 6 delivered. Rachel Fryer, Tarihi's mother, was responsible for the harm that ended her daughter's life. Following Tarihi's death, Fryer took steps to conceal what had happened. She placed her daughter's body in a suitcase and traveled north to Putnam County in north-central Florida, where she buried the suitcase in a shallow grave. The act of concealment, the distance traveled, the deliberateness of the burial, reflected an awareness of consequences that stood in stark contrast to whatever mental state or circumstance had preceded it. The investigation that led to Rachel Fryer's arrest and the discovery of Tarihi's remains was conducted across jurisdictions, with the coordination between Miami-Dade law enforcement and investigators in Putnam County that cases involving concealment across county lines require. When the evidence had been gathered, when the sequence of events had been reconstructed and documented, Fryer was charged with second-degree murder in connection with Tarihi's death. The legal proceedings that followed moved through Florida's court system over the months after the arrest. In June of 2016, more than 2 years after Tarihi's death, Rachel Fryer entered a guilty plea to second-degree murder. She was sentenced to 30 years in prison, to be followed by 30 years of probation. The sentence, delivered by the court after the guilty plea, reflected the gravity of what she had done. 30 years of incarceration. 30 years of supervised probation after that. Rachel Fryer will be an elderly woman before Florida's criminal justice system considers her debt to the law paid in full. The length of that sentence matters. It matters not because punishment alone constitutes justice. No sentence restores Tarihi Gordon to the 2 years of life she was given before it was taken from her, and no sentence returns to her the decades of life she never had the chance to live. But sentences of this magnitude serve a purpose beyond the individual case. They represent a public declaration, made through the formal mechanisms of the legal system, that the life of a 2-year-old child has infinite value, and that those who take such a life will be held accountable by the full weight of Florida law. What the Fryer case also revealed, and what it shares with many cases of its kind, is the degree to which the harm done to Tarihi did not begin on February 6, 2014. The evidence of ongoing abuse, the pattern of harm that preceded the final incident, points toward a situation that had been developing for a period of time before its worst conclusion. Child welfare advocates and investigators who study these cases consistently emphasize that the most dangerous period for a child in an abusive household is not a single dramatic moment, but the slow accumulation of harm that occurs when the pattern of abuse is allowed to continue without intervention. Florida's child welfare system, the Department of Children and Families, the network of community-based care organizations, the child protective investigators who respond to reports of concern, is designed to interrupt that pattern before it reaches its worst outcome. That system does not always succeed. It is under-resourced, overburdened, and operating in conditions of persistent difficulty. But it is the system that exists, and making it more effective, giving it the funding, the staffing, the training, and the support it needs to actually protect children like Tarihi Gordon, is the most direct way that a community can respond to the lesson this case teaches. The Florida Abuse Hotline, 1-800-962-2873, is the number to call if you believe a child is being harmed. The call can be made anonymously. The call costs nothing. And the call that is made before the worst happens is the call that gives a child like Tarihi Gordon the chance she deserved. Tarihi Gordon was 2 years old. She had a face, a voice, a laugh, and a name. She had a life that was just beginning. Rachel Fryer is serving 30 years in a Florida prison for what she did to that life. And Tarihi's name is part of the public record now, a record that belongs to everyone who believes that children deserve to be protected. If this story moved you, please take a moment to like this video and subscribe to Cold Case Hour. Every comment, every like, and every new subscriber is support for the work of telling these stories with the seriousness and respect that the victims deserve. Case 7, Natalia Munoz-Paulino, July 2nd, 2024, Miami-Dade County. When a child who cannot yet walk, cannot yet speak, cannot yet do anything more than exist in the complete and total dependency of infancy, is brought to a hospital, and when the medical professionals who examine that child find evidence of harm that should not be present in any infant, harm that could only have come from the environment in which that child was living, the investigation that follows is one of the most urgent that any child welfare or law enforcement system undertakes. The infant cannot tell investigators what happened. The infant cannot identify the source of harm. The infant cannot describe the conditions of the home. All of that must be reconstructed from the medical evidence, from the physical evidence, from interviews with adults, and from the painstaking work of investigators who understand that every hour matters when a child's life is at stake. The case of Natalia Munoz-Paulino and her 9-month-old son is a case that began on July 2nd, 2024, when the child was brought to a medical facility in Miami-Dade County. He was 9 months old. He should not have been there under those circumstances. And the medical findings that came back from the examination of this 9-month-old infant were among the most alarming that the investigators assigned to the case would encounter in their careers. Toxicology results indicated that the infant had ingested substances, specifically methamphetamine and cocaine, at levels that were, according to the medical examiner's findings, lethal. These were not trace amounts. These were not levels consistent with accidental secondary exposure of the kind that might occur if a child happened to be present in a space where drug use was occurring. The levels documented in the toxicology report were consistent with direct ingestion of significant quantities of highly dangerous controlled substances. A 9-month-old child. Methamphetamine and cocaine. In quantities sufficient to end his life. The infant did not survive. He was 9 months old, and he did not survive the conditions in which he had been living and the harm that those conditions had caused his body. The autopsy that followed the infant's death added additional detail to a picture that was already devastating. Examiners found evidence of foreign objects in the child's digestive system, material that was documented as including eggshells and feathers. This finding, taken together with the toxicology results, painted a picture of an infant who had been subjected to conditions of profound neglect and harm over a period that was not confined to a single day or incident. The presence of foreign objects in an infant's digestive system is an indicator of a caregiving environment that was not providing even the most basic standards of safe feeding and supervision. Natalia Munoz-Paulino, the child's mother, was interviewed by investigators in the aftermath of the infant's death. Her accounts of what had happened were, according to the investigators who documented them, inconsistent and contradictory. She offered multiple different explanations for how her son had come to be in the condition in which he arrived at the medical facility. One account suggested the child had drowned. Another suggested he had fallen. The inconsistency of those accounts, taken together with the medical evidence that pointed to a very specific and very different cause of harm, focused the investigation on Munoz-Paulino as the primary subject. The investigation that followed the child's death in July of 2024 continued for months. The forensic work was detailed and careful. The building of a case in circumstances where the primary victim cannot testify, where the cause of harm must be established entirely through physical and medical evidence, is work that requires precision and patience. In November of 2025, more than a year after the child's death, Natalia Munoz-Paulino was arrested and charged by the Miami-Dade State Attorney's Office with second-degree murder and aggravated child abuse. The charges, filed in November of 2025, reflected the determination of investigators and prosecutors that the evidence was sufficient to support felony charges of the most serious magnitude. Second-degree murder under Florida law carries a sentence of up to life in prison. Aggravated child abuse, particularly in cases involving an infant and the nature of harm documented here, carries severe penalties in its own right. The two charges together reflected the full scope of what investigators believed the evidence showed. The Munoz-Paulino case is a stark illustration of the particular vulnerability of infants in the care of individuals who are themselves struggling with substance use disorder. Infants cannot protect themselves. They cannot seek help. They cannot remove themselves from a dangerous environment. They are entirely dependent on the choices made by the adults responsible for them. When those adults are in the grip of a substance use disorder that has overtaken their capacity to provide safe and appropriate care, the infant in their care is in a position of danger that is invisible to the outside world until a crisis forces it into view. The Florida Child Welfare System and the Broward and Miami-Dade networks of early childhood services include programs specifically designed to identify and support families where parental substance use creates risk for young children. Substance-exposed newborn protocols, administered through the Florida Department of Children and Families, are designed to identify infants who may be at risk from the point of birth and to connect families with the intervention and support they need. These protocols exist because the community has recognized that early identification and early support are the most effective tools available for protecting the most vulnerable children. A 9-month-old boy. He did not survive July 2, 2024. His life was 9 months long, and in those 9 months, the care that every infant deserves was not consistently present. The investigation conducted by Miami-Dade law enforcement, the forensic work documented in the autopsy and toxicology reports, and the charges filed against Natalia Munoz-Paulino in November of 2025 represent the justice system's response to what happened to that child. The outcome of the proceedings against Munoz-Paulino will be a matter of public record. 9 months. That is all he had. And the justice system of Miami-Dade County is working to ensure that what happened to him in those 9 months is not ignored, not minimized, and not allowed to pass without full legal accountability for the person the evidence identifies as responsible. Please like this video and subscribe to Cold Case Hour. If you found this case important, leave a comment below. Your support makes it possible for this channel to continue this work. Case 8, Gina Emanuel, November 3, 2018, Miami-Dade County. There is a particular weight that attaches to cases involving individuals who occupy positions of professional trust in the care of others. A registered nurse is not simply a person with a job. A registered nurse is a person who has undertaken, through years of training and through the explicit professional commitment that licensure represents, to care for those who are most vulnerable, the sick, the injured, the very young, the very old, those who cannot care for themselves. The nurse-patient relationship is built on a foundation of trust so fundamental that its violation carries a moral weight that goes beyond the legal charges that follow it. When a registered nurse is found to have engaged in behavior that is the precise opposite of care, behavior that causes harm rather than preventing it, behavior that uses the knowledge and access that training provides not to heal but to hurt, the community's sense of betrayal is profound and not easily resolved. Gina Emanuel was a registered nurse living and working in Miami-Dade County. She was also an adoptive mother. Over a period leading up to November 3, 2018, she had adopted 3 sisters, bringing them into her home, and, by the formal and legal terms of the adoption, assuming the full responsibilities of a parent for their welfare, their safety, and their development. What those three sisters experienced inside Gina Emanuel's home over the months that followed their placement, there bears no relationship to any concept of care, whether professional or parental. The investigation that eventually brought Emanuel's conduct to light, the investigation that was triggered by the death of one of the children and that uncovered conditions affecting all three, documented a pattern of abuse that was systematic, sustained, and extreme in its nature. The three sisters were subjected to conditions of severe deprivation. They were denied adequate nutrition over a sustained period. They were subjected to degrading and harmful treatment that investigators documented in detail and that the court proceedings placed on the record. They were caused physical harm, including harm to their hands through exposure to a hot stove. They were subjected to conditions of confinement that had no legitimate basis in any recognizable parenting practice. These were not incidents. This was a sustained pattern, operating over months, inside a home that had been trusted by the adoption system to be a place of safety and care for three children who had already experienced the loss of their birth family. 7-year-old Samaya, one of the three adopted sisters and the child who ultimately lost her life, developed pneumonia at some point during the period in which she was living in Gina Emanuel's home. Pneumonia in a child is a serious medical condition. In a household where a registered nurse is present, a person with the training to recognize the symptoms of respiratory infection, to understand the trajectory of an untreated respiratory illness in a young child, to know exactly what the absence of medical intervention means in such a case. The failure to seek medical care for a child with pneumonia is not a lapse of attention. It is a choice. Samaya was not taken for medical treatment. She was not brought to the attention of emergency services. She was confined, taped to a chair, according to the findings documented in the investigation, and left without the medical care that her condition required. On November 3, 2018, Samaya did not survive. She was 7 years old. The immediate cause of her death was medical neglect in circumstances where the person responsible for her care had both the knowledge and the access to provide or obtain treatment, and chose neither. The investigation that followed Samaya's death led to Gina Emanuel's arrest and the formal charging of the case by the Miami-Dade State Attorney's Office. The charges included first-degree murder. The case proceeded through the Miami-Dade court system over the years that followed, moving through the detailed and often extended pretrial process that capital and first-degree murder cases in Florida require. In April of 2025, more than 6 years after Samaya's death on November 3, 2018, Gina Emanuel was convicted of first-degree murder. The conviction was delivered by a Miami-Dade jury following a trial in which the evidence gathered by investigators over those 6 years was presented in full. On April 30, 2025, Gina Emanuel was sentenced to life in prison. Life in prison. That is the sentence the court delivered. It is the most severe sentence available in this case. The sentence that Florida law reserves for those whose conduct is found, by a jury of their peers, to meet the highest threshold of criminal culpability. The jury heard the evidence. The jury reached its verdict, and the court imposed the maximum sentence. The two surviving sisters, the girls who were in that home alongside Samaya, who experienced the same conditions, who lived through what their youngest sister did not, survived. They required and continue to require the kind of sustained, professional, and compassionate support that children who have experienced prolonged abuse at the hands of a caregiver need to process what happened to them and to build toward a future. The child welfare and therapeutic support systems that work with survivors of prolonged childhood abuse are doing work that is as important as any work done in a courtroom. The adoption system that placed 3 sisters in Gina Emanuel's home, a system that is designed to find safe, nurturing homes for children who have already lost their birth family, was failed by the information available at the time of placement and by the oversight mechanisms that existed once placement occurred. Every case of this kind that comes to light in the court system generates a set of questions about the adequacy of the home study process, the frequency and quality of post-placement visits, and the systems through which adoptive parents' fitness to parent is assessed not just at the point of placement, but on an ongoing basis. Those questions are not comfortable ones, but they are necessary ones, and the child welfare community in Florida and nationally has continued to work through them in the years since Samaya's death. The Florida Department of Children and Families Adoption Program and its oversight mechanisms are subjects of ongoing policy review and reform. Advocacy organizations including the Florida Coalition Against Domestic Violence and the Child Welfare League of America maintain resources and conduct advocacy aimed at strengthening the protections available to children in adoptive and foster care placements. These efforts are part of the broader work of ensuring that 3 little girls in a Miami-Dade home are never again left without someone checking on them, asking the hard questions, and acting on the answers. Samaya was 7 years old. She had 2 sisters who loved her. She had a name and a face and a life that the adoption system had promised to protect. Gina Emanuel is serving a life sentence in a Florida prison. Justice, in this case, arrived through the formal mechanisms of the court system, through a jury's verdict and a judge's sentence delivered in April of 2025. It arrived more than 6 years after November 3, 2018. That is the pace of the legal system. It is imperfect and it is slow. But in this case, it arrived. Samaya deserved more than 7 years. She deserved the whole of a life. The sentence handed down on April 30, 2025, says that the community of Miami-Dade County knows that, and that it will not pretend otherwise. Please like this video and subscribe to Cold Case Hour. If Samaya's story moved you, if you believe her name deserves to be part of the public conversation about how we protect children, share this video, leave a comment, and join this community. It is the most direct thing you can do from where you are sitting right now. Case 9, Naomi Ruiz, January 2025, Miami-Dade County. Not every case that enters the Miami-Dade child welfare and criminal justice system arrives with the dramatic force of the cases that appear on the front pages of newspapers and the lead segments of television broadcasts. Some cases arrive quietly, a report filed, an investigation opened, an arrest made, and are processed through the system without the level of public attention that the most severe cases generate. But the quiet cases carry their own weight. They represent the vast, largely invisible volume of child welfare crises that occur in homes across Miami-Dade County every month, every week, every day. Crises that do not always produce the outcomes that the most severe cases produce, but that involve children whose safety and well-being are just as real, just as important, and just as worthy of the community's attention and the system's full resources. The case of Naomi Ruiz, documented in January of 2025 in Miami-Dade County, is one of those cases. It is a case that, measured against some of the others in this documentary, may appear less severe in its immediate outcome. The child in this case, a 5-month-old infant, was alive when investigators became involved. The harm that had been done to this infant was serious and was cause for urgent concern, but it was not irreversible. And that distinction, between a case where intervention arrives in time and a case where it does not, is the most important distinction in child welfare work. In January of 2025, Miami-Dade investigators became aware of a situation involving Naomi Ruiz and her 5-month-old son. The circumstances that triggered the investigation involved an incident in which the infant was injured. A fall was reported. In the course of the investigation that followed, medical examination of the infant produced toxicology findings that became a central element of the case. The infant was found to have cocaine present in his system. A 5-month-old child. Cocaine. The presence of cocaine in an infant's system is not a finding that can be explained by accident or coincidence. An infant does not access controlled substances independently. An infant does not make choices about the environment in which it lives or the substances to which it is exposed. The finding pointed directly to the conditions in the household and to the responsibility of the adults caring for the child for the situation in which he found himself. Naomi Ruiz was also tested in the course of the investigation. She, too, tested positive. The investigation further determined, based on the totality of the evidence gathered, that she had failed to provide for the infant's basic needs in ways that went beyond the toxicology finding alone. The picture that emerged from the investigation was one of an infant living in conditions where the most fundamental requirements of safe and appropriate infant care were not consistently being met. Ruiz was charged with child neglect. Under Florida law, child neglect, particularly in cases involving an infant and the degree of failure to provide basic care documented in this investigation, is a serious criminal charge that carries significant potential penalties and that triggers a range of child welfare interventions aimed at ensuring the child's ongoing safety. The 5-month-old infant at the center of this case was removed from the home and placed in protective care through the Miami-Dade child welfare system. His immediate safety was secured. The work of ensuring his long-term well-being, addressing any developmental or health consequences of the exposure he experienced, providing him with the consistent and nurturing care that infants require for healthy development, and placing him in an environment where those needs will be reliably met, is the longer-term task of the system now responsible for him. The Ruiz case is, in a meaningful sense, a case about the intersection of parental substance use disorder and infant safety. Substance use disorder is a health condition, a chronic, treatable condition that affects brain function and behavior in ways that can, when left untreated, have serious consequences for the people in the lives of those who are struggling with it. When an individual with untreated substance use disorder is also the primary caregiver of an infant, the infant is at risk in ways that require the attention and intervention of both the healthcare system and the child welfare system. Miami-Dade County has programs specifically designed to address this intersection. Substance Abuse and Mental Health Services Administration resources are available for individuals seeking treatment for substance use disorder. The Florida Department of Children and Families operates family support programs that include parenting assistance and substance use treatment referrals for parents involved in the child welfare system. These programs exist because the community has recognized that the most effective way to protect the children of parents struggling with substance use disorder is to address the disorder itself, not just to remove the child and close the file, but to provide the parent with the opportunity to access treatment, to stabilize, and to become capable of providing the care their child needs. Whether Naomi Ruiz accesses those opportunities, whether the child welfare system is able to support her in doing so, and what the ultimate outcome is for her 5-month-old son, those questions will be answered over the months and years ahead in the records of the Miami-Dade court system and the child welfare case files that the Department of Children and Families maintains. What is certain is this: a 5-month-old infant is alive. He is in protective care. He has the chance, still, at this early stage, to grow up in an environment that meets his needs, to develop without the harm that would have come from continued exposure to the conditions documented in this investigation, and to have the childhood he deserves. That chance exists because the system intervened before the worst happened. That is what early intervention looks like. That is what it does. And every time it works, every time a child is reached before the worst outcome occurs, it is a reminder of why the investment in those systems, imperfect as they are, is among the most important investments a community can make. The legal proceedings against Naomi Ruiz are ongoing in Miami-Dade County. The charges are serious. The evidence is documented. And the infant at the center of the case has been given the chance he deserves. Please take a moment to like this video and subscribe to Cold Case Hour. Every subscriber, every like, and every comment is support for the work of telling these stories and keeping them in the public conversation where they belong. Case 10, Jazmin Paez, July 18, 2023, Miami-Dade County. The final case in this documentary is, in one important sense, the most unusual of the 10. It is the case in which no child was physically harmed. The 3-year-old at the center of the case is alive. He was never attacked, never injured, never exposed to direct violence. The harm that was planned for him did not occur. And the reason it did not occur is one of the more remarkable features of this particular story, a feature that, once understood, raises its own set of deeply important questions about the systems and structures that exist to protect children from threats that come not from strangers, but from those closest to them. In the summer of 2023, an individual in Miami-Dade County accessed a website that appeared, on its surface, to offer a service that is not only illegal, but among the most serious crimes contemplated under Florida and federal law: the hiring of a person to kill someone in exchange for money. The individual who accessed that website and submitted what appeared to be a request for that service was Jazmin Paez. The intended target of the request she submitted was her own 3-year-old son. The website Paez used was not, in fact, what it appeared to be. It was a parody website, a site that was designed to look like a dark web hitman for hire service, but was not connected to any actual criminal network and did not have the capacity to fulfill the requests submitted to it. Whether Paez understood this at the time she submitted her request is part of the factual record of the case. What is not in dispute is the nature of the request she submitted. She offered $3,000 for the killing of her child. She provided the child's exact location. She included a photograph. The reason she gave, the motive that investigators documented in the record of the case, was that her boyfriend did not want to be in a relationship with a woman who had children. She wanted to remove the child from her life so that the relationship could continue without the complication that his existence represented. The case came to the attention of law enforcement through the mechanisms by which these parody websites are monitored, a process that exists precisely because law enforcement and the operators of such sites have recognized that real individuals with real intent do attempt to use them, and that the attempt itself, even when it targets a fake service, constitutes a serious criminal offense. On July 18, 2023, Jazmin Paez was arrested. She was charged in Miami-Dade County with solicitation of murder, a serious felony under Florida law regardless of whether the attempted solicitation was directed at an actual criminal operative or at a site that could not fulfill the request. The legal proceedings that followed involved the full complexity that cases of this kind tend to generate. The question of Jazmin Paez's mental state, her capacity to form criminal intent, her awareness of the nature of what she was doing, the degree to which any recognized psychiatric condition may have influenced her actions, was examined as part of the defense case. She was diagnosed with schizophrenia during the course of the proceedings. That diagnosis became a central element of the sentencing arguments. On March 23, 2026, the Miami-Dade court reached a disposition in the Paez case. She was sentenced to 14 years of supervision, 2 years of community control, the most restrictive form of supervised release under Florida law, sometimes described as house arrest, followed by 12 years of probation. The sentence included mandatory mental health treatment as a condition of the supervision. The schizophrenia diagnosis and the requirement of ongoing psychiatric treatment were incorporated into the terms of the disposition. The sentence in the Paez case is one that will invite reflection and debate from different perspectives. Those who focus primarily on the severity of the intended act, the solicitation of the killing of a 3-year-old child, will note that 14 years of supervision, with no period of incarceration, is a disposition that falls well short of the most severe outcomes the case could have produced. Those who focus on the presence of a serious mental illness diagnosis and the documented psychiatric dimensions of Paez's case will note that the sentence reflects the court's assessment that treatment and supervised release may serve the goals of public safety and rehabilitation more effectively than incarceration alone in a case involving an individual whose actions appear to have been significantly influenced by an untreated mental health condition. The 3-year-old child at the center of the case was alive and physically unharmed. That is the outcome that the arrest and the case prevented. The outcome that did not happen because the website Paez used was a parody site, because law enforcement monitoring of such sites was in place, and because the arrest occurred before any actual criminal network was contacted. The child was placed in a safe environment following his mother's arrest and has remained safe throughout the legal proceedings. The Paez case raises questions about the intersection of parental mental illness and child safety that echo through several of the cases in this documentary. Schizophrenia is a serious and treatable psychiatric condition. When it is untreated, when the individual who is experiencing it has not been diagnosed or is not receiving appropriate medication and therapeutic support, it can produce distorted thinking of precisely the kind that the Paez case documents. The question of how the systems around an individual with schizophrenia, family members, healthcare providers, social services, and legal systems, can and should respond to signs of untreated psychiatric illness before a crisis point is reached is a question with implications for child safety that extend far beyond this individual case. The Miami-Dade court's decision to incorporate mandatory mental health treatment into the disposition of the Paez case reflects a recognition that the long-term safety of the child and of the community is best served not by incarceration alone, but by ensuring that Jazmin Paez receives the ongoing psychiatric support she needs to manage her condition. The conditions of her supervision are strict. The monitoring mechanisms of community control and probation are designed to ensure compliance, and the court's records will reflect whether those conditions are met. The 3-year-old whose photograph and location Jazmin Paez sent to a parody hitman website in the summer of 2023 is now several years older. He is growing up. He is going through the stages of childhood, The ones that all of the children in this documentary who lost their lives never reached. He is alive because of an accident of technology, because the website his mother chose to use was not what she believed it to be. That accident of technology and the law enforcement monitoring that made his mother's arrest possible are the reasons he is alive today. The legal systems of Miami-Dade County and the state of Florida processed this case over the nearly 3 years between his mother's arrest and her sentencing. The outcome is on the record. The child is safe. And the case stands as a reminder, quiet, unusual, and in its own way deeply significant, that the protection of children sometimes comes not from a dramatic rescue or a first responder's intervention, but from the steady, unglamorous, essential work of monitoring and enforcement that happens in the background of daily life without anyone noticing, until the day it saves a life. This community, Miami-Dade County, South Florida, this city that has seen so much and endured so much and built so much, carries forward the names of the children in these 10 cases. The ones who did not survive. The ones who did. The ones whose survival was a matter of luck or technology or a stranger's courage. All of them are part of the record. All of them deserve to be remembered. And the work of the courts, the child welfare systems, the mental health services, and the communities around them is the work of making sure that every child who comes after them is a little safer, a little better protected, a little more certain of the one thing every child deserves, the chance to grow up. Across the 10 cases in this documentary, one truth is consistent. Every child at the center of these stories deserved better. Better protection, better intervention, better systems of care around the families that were failing them. The legal systems of Miami-Dade County and Broward County have worked, imperfectly and at varying speeds, to hold accountable those whose actions caused irreversible harm. The child welfare systems, the mental health services, and the community organizations that exist in South Florida are working, with inadequate resources but genuine commitment, to ensure that the next child in crisis is reached before the worst happens. If you are concerned about the welfare of a child in your community, please contact the Florida Child Abuse Hotline at 1-800-962-2873. The call is free, can be made anonymously, and may be the most important call you ever make. If you or someone you know is experiencing a mental health crisis, please contact the Florida Crisis Hotline at 1-800-273-8255, available 24 hours a day, 7 days a week. These resources exist because communities decided that children deserve protection not just in courtrooms, but in every space where a family is struggling and every moment when the worst outcome can still be prevented. Thank you for watching Cold Case Hour. If these 10 stories moved you, if you believe that the children in these cases deserve to be remembered, and that the communities of Miami-Dade and South Florida deserve a channel that takes this work seriously, please take one moment right now to like this video, leave a comment below, and subscribe to Cold Case Hour. Your subscription is free. Your support is everything. And every new member of this community is a signal to this platform that content that honors victims, serves justice, and educates communities deserves to reach the widest possible audience. Like, comment, subscribe, and thank you for being here.